Former United States Attorney in the Northern District of Texas, Sarah Saldaña, thank you so much for joining us. We appreciate it as always. You are one of 14 former state and federal prosecutors who have signed off on this amicus brief to the Second Court of Appeals in Fort Worth in the Crystal Mason case on her behalf. Why was this so important for you to sign this and be a part of this?
Jack, there's already a lot of discussion about election fraud that's hit the media and all kinds of sources of information, some of which is not accurate. And the first question is there this vast conspiracy of election fraud in the state of Texas? I think the facts show that that is not the case, but that isn't what got me interested in this case. What got me interested in this case, and certainly being part of the States United network of former prosecutors, it is so important to us. It is in our DNA as former prosecutors to ensure that the election process has integrity, and those who are eligible and wish to vote do get to vote, so that things that happen that are patently unjust or unfair gets our attention. And it's all over, our reach is all over the country, not just in the Dallas-Fort Worth area, but this case has certainly surfaced as a significant one. And let me say too, let me be sure to clarify, also as part of my DNA is prosecution for offenses under the federal laws. I am not in the business or practice of second guessing the decisions of prosecutors. And so I just want to be sure people understand it is my natural inclination to see where the legitimacy of the indictment and prosecution is. But here it is just so blatantly inappropriate, not really under the law. And I think that the Texas Court of Criminal Appeals has recently made that pretty clear.
I was going to say, I mean, you're one of the toughest prosecutors in North Texas, and my question to you is: the brief says that Crystal Mason should not have been charged, much less convicted in this case. Why not?
Well, because as we now know very clearly, and I think it was clear before, your own common sense tells you there's got to be an actual intent, actual knowledge that the conduct you're engaging in is illegal, and that those facts are not there. And I believe that'll be coming up in this hearing tomorrow, next Tuesday. But what is clear to me is that certainly the prosecutor has wide berth to decide which cases to prosecute, even those that do come under a statute, appropriately, unlike this one. But that it should never have been charged under the laws of the state of Texas, and it should never have been charged as a legal and useful use of prosecutor resources. There are other things to prosecute that are clear, have actual knowledge and intent as part of it, that really do address massive problems, and there are good reasons to prosecute. Again, it's not that I'm in the business of second guessing prosecutorial decisions, but this one just stands out.
Why is intent so important?
Well, because obviously the legislature, the whole federal election system, but the state legislature in particular, has recognized that somebody may come to a polling place and believe they're eligible to vote. And they've laid out a whole system which Ms. Mason took advantage of here, and which the clerk that was present at the voting place acknowledged to her that she could cast a provisional ballot because she wasn't showing up on the polls and on the register. And so under the law, she cast her provisional ballot, believing that she had a basis. She had served her sentence out, and if the conviction was final, the sentence had been served. She was still, the little hook was that she was still on supervised release. That is, once you have served your sentence in the institution, the penal institution, then you have a period of time that you're still under the jurisdiction of the court to be observing and making sure you don't get into trouble again. Well, that's the place she was at. So intent is critical because that's where we want to catch those that are trying to commit fraud and go against the integrity of the election system, is those people who intend to circumvent the eligibility requirements. And that simply wasn't the case here.
And just out of curiosity, just from my knowledge, when you're on supervised release after you've been in prison, so once you leave prison and are on supervised release, have you finished your sentence? How does that work? I was just curious.
Supervised release is actually part of the sentence. Mind you, I'm speaking to you as a well-seasoned prosecutor and a lawyer of 35 years, okay? I don't know that average Joes know this, but unless they go over it with them when they're leaving the institution. But the supervised release provision is part of their sentence. So the part that says you will be incarcerated was completed. There was this last piece that says, but don't get in trouble for, I don't know if she was under a 2 or 3 year supervised release provision, but that was part of the sentence. So it can't be said that it was not part of the sentence, but I think to the average person, even to me as a lawyer, you kind of think sometimes, well, she's out of prison, her sentence is complete. I think that's an honest mistake.
And my last question to you is, and I think this is why I'm really even more interested in this case now than before, is that the Texas Legislature right now is debating whether to increase the penalties back to a felony. And in the state Senate already, they've passed a bill that would remove the intent requirement. And I'm quoting the author of that bill. He said, ignorance of the law is not a defense when you're a convicted felon. And so just yesterday, the House had a hearing on its own version of this bill, and they said, no, intent is still part of their bill. And so I'm wondering, what do you make of this? The fact that the Senate is now passed, and it's going to have to be, hashed out, I guess, in a compromise with the House on removing intent, and that ignorance would not be a defense under their legislation.
Well, that ignores the whole history of the prior statute, of the statute that's actually present now, and even the prior statute, that the statute was clarified in 21 to say very clearly actual knowledge is a part of this. And of course, that's what this effort is intended to address is, no, we are going to make even innocent mistakes punishable under the criminal statutes of this state. It is once again trying to seek a remedy to a problem that doesn't exist. There is not massive fraud in the state of Texas, but more importantly, I am hopeful that the bipartisan group of legislators who changed the statute or made very clear in the statute in 21, saying specifically actual knowledge is required here, that they will prevail again, because in the comments to the legislation, it says clearly that we would require actual knowledge. We cannot make innocent mistakes punishable under the statute. Once again, the whole provisional ballot system is intended to catch problems or issues, not intentional fraud, but that was not the case here. And so the provisional system worked. She was found not to be eligible, and her penalty, which should have ended there, was not to be able to vote in that election. So if you go to the court's opinion in in which they remanded the case back for this hearing on Tuesday, it says very clearly, prosecutors and even some courts have made a mistake of not requiring actual knowledge. And you will need to do that here. You'll need to go back and look at this and see if you have evidence of that. I am hopeful that the court will, the court below will do the right thing.
And basically what, vacate the conviction?
Yes. I mean, think about it for your viewing public. We want to do those things. We want to catch election fraud. Absolutely. I was the election fraud officer in the Northern District of Texas for years. But what we don't want to do is to put fear into people that any innocent mistake like this will actually put them in prison. In this case, she was imposed a 5-year sentence, Jack, and that is just so disproportionate in any event. But more importantly, her mistake was an innocent one, and we shouldn't punish voters or people who are attempting to vote with innocent mistakes.
Former United States Attorney of the Northern District of Texas, Sarah Saldaña, thank you so much for your insight. We appreciate it.